Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. So, does Amber Heard have any chance on appeal? We'll talk about that in a moment. When a party appeals, what they are saying to the appellate court is that the judge made an error. That's because they can't come in and say the jury made an error. They have to come in and say the judge made an error, and these are the errors that the judge made. Now, there tend to be two kinds of review at appellate courts. The first is called de novo review. And de novo review is where the Court of Appeals or the Supreme Court looks at the question of law. In other words, what is the law that applies here? How should it be applied? That is a legal conclusion, and the court's legal conclusions are always subject to de novo review. The other level of review is called abuse of discretion. Abuse of discretion is a much, much higher threshold for appellate relief. To get relief from a court abusing its discretion, you have to show that you were prejudiced by it such that the result of the trial might have been different otherwise. Now, just how deferential is the abuse of discretion standard on appellate review? Well, in Missouri, where I'm licensed, the standard for abuse of discretion is if reasonable minds could differ about the propriety of the trial court's action, then there is no abuse of discretion. So in other words, if it's even a reasonably close call as to whether a piece of evidence is relevant or irrelevant, the trial judge gets the last word. It is only in that situation where the murder weapon is a huge bloody butcher knife and the decedent died from a wound from a butcher knife, and the trial court says, no, I'm excluding that on the basis of relevance. Now there you go. That is quite possibly an abuse of discretion right there. Now that's kind of a oversimplified explanation of it. But the bottom line is the trial court gets the right to decide most of these questions. And it's insulated from review not only by that large, or I should say that rather strict standard for appellate review, but it's further limited by the requirement to show prejudice. Now, when most folks talk about prejudice, they think about somebody that doesn't like someone because of their religion or the color of their skin or something like that. And indeed, that's a form of prejudice. But in this case, legal prejudice basically means that someone's rights were violated. Someone basically was denied a fair trial because a piece of evidence was withheld. And the result, if that evidence had come in, might very well be different. Now, on all the things that go into instructing, that go into a trial court's decisions, like instructing a jury, as long as they get the law right and they articulate the law correctly, if they slightly misapply the law or if they give too much leeway to one side or the other, it's probably not going to be something that an appellate court is going to take action on. So again, not only does it have to be a really bad call, it has to be like the Don Dinkinger call in the 1985 World Series where he called somebody safe that was probably out. It not only has to be that, but it also has to be, hey, this would have changed the entire course of the World Series. And indeed, in that case, it probably would have. So it's important to remember that an abuse of discretion standard is so lenient and so flexible that in most cases a trial court will be able to decide the issues without having to worry about whether or not they're going to be second guessed. And finally, just a word about this particular judge. There are some judges who let parties try their case. And when you hear somebody talk about a judge who lets the parties try their case, it means they are very slow to rule on objections, and they, generally speaking, don't rule on a lot of them favorably. If it's a close call on relevance, it goes to the person offering the evidence. If it's not a close call, then probably they grant the objection. But if it's fairly close, it goes to the person offering the evidence. These are the situations, and those are the kinds of judges who tend to get reversed for the admission of evidence. They tend to be the very favorite judges of trial lawyers because trial lawyers, whether they're plaintiffs or defense, like to get in evidence because they believe that evidence will help their case. But appellate courts have the job of keeping the game fair, keeping the rules straight. And when you start letting people chip away at those rules, it doesn't do much for the regard that people hold the law in. So, hopefully that gives you an opportunity to understand what Ms. Hurd is facing going forward in an appellate proceeding based on the results of her trial. Now, I wouldn't predetermine the outcome to be negative. There is a possibility she could make some arguments that would give her a potential to go forward and do well. But you also have to remember that if Ms. Hurd appeals, Mr. Depp will probably cross appeal and will challenge the award to Ms. Hurd on the basis of statements made by an attorney where there was never any proof offered that he made those statements. And I believe a court would exclude would reverse that $2 million judgment because that was a rule, that submitting that was a legal error on the part of the judge in granting that jury instruction, not so much an abuse of discretion. So hopefully if you had an opportunity to watch the trial, you have a better feel for what I'm talking about here. And if not, I hope you'll have an opportunity to go back and get on Nick Rekieta's channel and look through the Rekieta files for the actual testimony and review the testimony. There's also a channel called Law Nerd Clips, and there are some very good clips on there that review different parts of the trial. If you have any questions, please leave them in the comments down below. If you haven't already, please go over here and subscribe to our channel. Thank you very much for watching, and I hope you have a marvelous day.